No, I'm not sure how we can. Dan, can you mute them on this end?
I'm trying to.
Troy's hosting. I told Troy to, because Troy's the one that's.
So just so everyone understands that when we started back, Arcan had ended their broadcasting. So what has been brought? So everything you've heard until now hasn't been broadcasted. But what we will do is we will post the full viewing of today's hearing on our E&E YouTube channel after it's over. But we may want to take a quick 5-minute recess, and our tip, well, 5 always turns into 10, right? So,
all right, we're off the record for 5 minutes.
Recording stopped.
And then place up all the other drinks that I find out.
All right.
Recording in progress.
Okay, we're back on the record. I have one more comment card from Tetra Technologies, Alicia Boston. Come on up, ma'am. Have a seat.
Can you guys hear me? Okay. Good afternoon. I'm Alicia Boston. I was before this commission back in September to establish the Tetra Evergreen Brine Unit. I'm general counsel at Tetra, and I wanted to provide Tetra's views and thoughts on the matter that's before the commission today. Tetra recently received an order from the AOGC to establish the Tetra Evergreen Brine Unit, from which we intend to produce bromine and ultimately lithium. Although the standard lithium royalty matter before the commission today does not directly affect Tetra's new Evergreen Brine Unit, the outcome of this hearing will likely directly affect Tetra and other producers in the state. Based on our early economic work, the 12.5% rate on gross revenues from the sale of final products such as lithium carbonate, as proposed, is not economical. A 12.5% royalty structure may be common for wellhead sales of oil and gas, but should not be applied to brine production. From our perspective, we share the same view that it is important to distinguish an oil and gas royalty from a royalty on brine production. While oil and gas has value and available customers at the wellhead, brine does not. There is not a market where someone can buy or sell a barrel of brine. Unlike an oil and gas operator, a brine operator must invest beyond those wells and pipelines to also install processing and lithium extraction facilities that can remove the lithium from within that brine and then create a marketable product. From our own engineering and financial studies, as well as those published by Standard Lithium, the amount of capital investment to extract the lithium and convert it to a sellable product is estimated to be more than 4 times the amount of capital just to drill and complete the wells. In addition, even after the lithium is extracted from the brine, significant operating expense is still required to process that lithium into a refined specialty product that can be sold. The typical operating expenses as published are estimated to be in excess of $5,000 per metric ton. The 1/8 royalty that has been proposed is based on the gross proceeds from the sale of highly processed and refined lithium products, just as we would not base an oil and gas royalty on the retail price of gasoline. For these reasons, it is not appropriate to base the lithium royalty on the gross proceeds received from the sales of refined lithium products, without accounting for the substantial post-production capital and operating costs that will be incurred. Second, while oil and gas and mining markets are mature, it is important to recognize that lithium production from brine is in its infancy. In fact, at this time, there are no direct lithium extraction projects producing commercial quantities of lithium products anywhere in the U.S. A royalty structure for lithium needs to take into account the substantial risk and uncertainty that is being taken on by potential lithium projects. The technologies required, higher cost structure, brine concentration uncertainty, and limited customer base indicate that any royalty for lithium should be significantly less than oil, natural gas, or even bromine. The 12.5% proposal fundamentally fails to recognize this market reality. Both other jurisdictions and private parties impose royalties at rates similar to those proposed by Standard Lithium. We found 10+ lithium royalties in other jurisdictions, and none of those royalties for extracting lithium from brine have a 12.5% royalty rate on gross revenues. Lithium derivatives are a commodity, and as we know from every other commodity, they are subject to high pricing volatility. For instance, in the past 12 months, lithium carbonate prices have fallen 78%. Just 3 years ago, in November of 2020, lithium prices were $4,100 per metric ton, a price that would be less than the processing operating costs as estimated, and before accounting for the capital investment. Under such extreme pricing volatility, which is likely to persist in illiquid markets, a royalty of 12.5% of gross proceeds sale of lithium products will make these projects, in our opinion, uninvestable. Finally, we encourage the commissioners to set a lithium royalty that encourages investments in leading-edge lithium extraction technologies and infrastructure in Arkansas that will create a significant number of new jobs, provide mineral owners royalty income, and create more tax income to the state, counties, and cities in Southwest Arkansas. In order for the state of Arkansas to compete for investment dollars and be the first state with commercial direct lithium extraction operations, supported by billions of dollars of investment and great jobs, a reasonable royalty structure is required. Tetra believes the Standard Lithium royalty proposal is fair and equitable and will attract investment, add significant jobs, and reward landowners appropriately. The suggested 12.5% royalty will not encourage lithium producers to take the risk on new leading-edge technologies. Adopting a 12.5% royalty rate on gross proceeds instead can create the environment where lithium will continue to be sourced from other parts of the world to meet our nation's new energy demands and leave Arkansas's mineral and landowners on the sidelines. Thank you.
Thank you, Ms. Boston. That is the sum total of my comment cards. Hold on a second, Mr. Honey. Anybody else in the audience wish to comment or speak to this docket? For the record, there was none. Mr. Honey.
Yeah, just housekeeping. Like if and when a royalty is established and it's payable, LACES will process the royalty checks the same way they do bromine checks. LACES has asked that, at such time as a motion is made to establish royalty, that it include a provision that the lithium royalties will be paid in the same manner as bromine, i.e. quarterly, with the proviso that it can be accumulated up to $100 per year. The other housekeeping chore I'm requesting is that the request to operate the pilot plant be decided, if possible, first, and separately, before taking up the other issues. One final comment. Before, Standard Lithium can proceed with, finalizing loan arrangements, capital contributions, that kind of thing, the royalty has to be established. If the commission's wish is to continue this matter, to consider further or request further information, if at all possible, we had asked that it be taken up again at the January hearing, as opposed to putting off. We'd want to hear it in January if we can, rather than delaying it till, I guess, the March hearing in Hot Springs or the April hearing.
Is, Mr. Honey, is that your closing statement as well as your housekeeping, or?
No, I did not have a closing statement.
Mr. Perkins?
Closing statement.
Just a couple of comments to wrap up. You heard all the testimony from both sides. You heard Standard Lithium give their presentation. You heard Eric Kraus, and you heard Chip Bamberger. And you heard Dr. Robinson state that this project won't work at 12.5%, but you didn't hear why. You didn't see any data. He didn't give you any financial analysis, no background or support for that statement at all. What you got from Mr. Kraus was an analysis using their numbers of the finances with the economic model that they produced in a definitive feasibility study that demonstrated at 12.5% based on the base case that they presented that Dr. Robinson said was still good. Their internal rate of return would be still about 21%. That's double the average rate of return for mines and mineral extraction. That's 4 or 5 times the normal average rate of return for an oil and gas project. This is, like I said, it's more like they're building a processing facility. They're not building a production facility. And what they're going to produce there is lithium carbonate. That's what this royalty relates to. We think 12.5% is fair and equitable, and we ask that that's what you decide. Thank you.
Thank you, Mr. Perkins. Mr. Honey, I have. Sure thing. Go ahead, Mr. Honey.
I'll be brief. This question of fair and equitable compensation to the mineral owner has to be based on the value of the brine. That's the only thing they bring to the table. Is the raw material. And to say that 12.5% of the value of the finished product is fair and equitable compensation for providing the raw material, which is only a small part of the total contribution to the value of that final product, it just doesn't make any sense. There's a lot of intellectual property that is added to value. There's capital cost of this plant. And for the lithium owners to invest nothing and take no risk and yet receive a share of the profits rather than a fraction of 1/8 royalty on the value of the raw material that they provide is just fundamentally wrong.
Thank you, Mr. Honey. The question that I had for you was in terms of that first motion on the pilot plant continue operation. I assume you want that for another 12 months, or did you have a time frame in mind?
Well, we were contemplating that the royalty would be established and that we'd move forward with building a plant, so it would be ongoing authority with no sunset. In kind of the sense I'm getting is that perhaps sunset would be palatable mission. But we didn't request a specific time. We were asking for ongoing evergreen.
All right, with that, I'll call the evidentiary part of the record to a close. Commissioners, this matter is ready for adjudication. Do you want me to set the table for you in terms of what the 3 issues are and make a motion on each one of those issues? All right. So The first one is, can the pilot plant operate after December 5th? Is there a motion from the commission regarding that matter? Hold on. Motion from Commissioner Lawson, second from Commissioner Liner, is that right? Okay.
12 months or everything. I'd say everything.
All right, do you want, all right. Any further discussion? If not, show of hands. I have 8 yes votes, motion passes. Second item is pursuant to 1576-315C2. Can the plant profitably extract substances from the brine solution other than bromine? Is there a motion on that issue?
Discussion. We're not able to see the whole economics. We've not seen the total economics presented because of a ongoing proprietary discussion. And my recommendation would be to have Standard Lithium, the two atoms, lengths of Standard Lithium, show the economics to staff, Larry and perhaps Mr. Hilton, and also as so we got to determine that it's economic. Yeah. This is determining that it's an economic element.
So the first one is, commissioners, this next one that I've got teed up is, again, can the plant profitably extract substances from the brine solution other than bromine? In other words, can it profitably extract lithium? And then the third one, which would be, if you do establish a profitable extraction, what should be the fair and equitable basis for accounting separately to the royalty? So it's the royalty payment.
So in my mind, at this point, we haven't seen we've had a statement that at their proposed royalty that the plant would be profitable. But we haven't seen the data, and so my request would be that data be shown to staff.
So you're saying, Commissioner Wolford, that both of those in your mind are intertwined, both of those?
Unless I'm way off.
Okay. Well, I think he's cobbling them both together, Mr. Chairman.
But I'm just saying, you got to plug in some royalty to determine if you're profitable. And properly extract the product. And I'm not saying we're agreeing with that rule. I'm just saying, is there some rule? And I'm using their assumed rule is that starting. And then what's going to come next? I don't think I'm ready to determine the royalty at all.
Is there?
So basically what I'm saying is economics to be run to demonstrate that with economics they run at their proposed royalty, that is profitable. And the only way we can see it as fully profitable is if we have the proprietary information presented. And by using staff, we can, they should be protected by the trade secret rule, according to Shane.
Mr. Pinkleton, can you weigh in on that? Does the commission have? I know that my commission with DEQ does trade secret. I didn't know whether or not this commission had, and whether or not that might be a violation of the state FOI. Okay, here comes the secretary. Hold on.
Even we don't have a full policy.
Commissioners, I might have an answer for you from, Mr. Pinkleton in terms of the trade secret aspect. You're not Mr. Pinkleton.
I
Secretary,
guess if you stand here and don't answer long enough, I'll have to come up, right? I think what we're talking about specifically is under the Freedom of Information Act, what an agency or State Department has the authority to disclose or not disclose. And there is a trade secret exemption under the Freedom of Information Act. So if we received a request for a Freedom of Information Act request to disclose that information, that we could utilize that provision as a trade secret exemption to not disclose that information publicly. What may or may not be, I guess, probably the harder question is, which staff you're going to use and who has subject to that information and how closely held that information is.
well, and I'm guessing, I'm just gonna speculate that you're gonna get some objections from some other folks, like maybe Mr. Parkins on this entire thing as well.
Well, let me just say, and this isn't about freedom of information or whether there's authority for trade secrets at all. It's more basic. It's if the commission bases a decision on financial information that you don't disclose to anyone, how can, for example, if I disagree with it and I appeal it and I go to the court and say, well, they based it on some number they didn't tell us, they're going to say, you can't do that. I mean, that's my opinion. I don't think it can be done that way. I understand the concern and I'm not pushing back on that. I just think legally it's fraught with all kinds of problems.
And because of that, I hate to give advice on the fly.
And I'm not.
No, I understand.
And I think that needs a secondary point to whether or not we can withhold it using a trade secret exemption is how do you then utilize that information beyond Director Bingle or Administrator Bingle and staff to the commission being able to consider it for this purpose. So I'm going to go sit back down now. Exactly. That's the problem. It may not help you all.
Andy, do y'all have a lease agreement, contract? What kind of agreement do y'all have?
Yeah, you're back to asking questions, Mr. Chairman, and this is adjudication. We've almost stretched it even beyond that a little bit here. So is there just a motion from the commission to table the last two matters?
I make a motion to table
and take it up in January? Take it up in January, commission? Or just table it?
The challenge for this commission is how do we think we have an asset here, we being Arkansas, the United States of America, the world, that's very valuable. It takes 35 pounds of rare minerals to make one inch of 35. So lithium is part of that. And so we want to get this right, but we want to be fair to all the stakeholders. We want to be fair to our owners. We want to be fair to the operating companies, obviously, because it's got to work economically. So the challenge for us is we're trying to get there is to find that right balance that is fair and equitable to everybody.
So I think I had a motion from Commissioner Wolford to table, second from Commissioner Langley, Chair Langley. All right, Chair Langley. I believe that's the case. Any further discussion? If not, show of hand. Oh, Mr. Chairman.
set our meeting schedule. Yeah. Well, we got to vote on, well, we got to vote. The proposed meeting is in force. Easier for that to be able to say, swap, keep a month,
Hey, can y'all use the mic?
Yeah.
All right, there's a motion, there's a second. Any other discussion? If not, show of hands. I count 8 votes in favor, the motion passes. The last 2 items.
Judge, can I ask a question?
Yes, sir.
Is the commission going to want or expect some additional information? I mean, I don't quite understand. I mean, if you just need time to think about it, that's fine. It's none of my business. But I couldn't tell if this is tabling it to somehow obtain additional information or where we're going here.
I think, Mr. Perkins, what the commission is looking for is from additional financial information from Standard Chlorine and not Standard Lithium, sorry. And I believe that's their intent. But then you get into the weeds in terms of who can see it and how it's going to be presented in the whole bit. And I understand and appreciate your concerns as well in terms of trying to make a record for a potential appeal on information you haven't seen. Hopefully all that can be hammered out and ironed out by the January meeting.
So we can anticipate some interim correspondence about what you expect from the parties, perhaps? Is that where we're going here?
I'm optimistic that that's the plan.
Well, I think what he's saying is we hadn't made any demands from anybody. to do
Yeah,
it.
you haven't
Right.
just bring anything or.
I would like to see both parties make an effort. It is to canvass the abstract plans, the courthouses and the landmen that are working in South Arkansas and bring before the commission a copy of a lease paid up for the development of lithium that includes the highest and best terms available within the region. Thank you.
Just an answer, Alan, for me, the economics are incomplete.
I understand.
Yeah.
Just trying to figure out how we can help you.
Yeah.
That's all.
I have no way to compel it.
Yeah. I understand.
Other than time tends to compel it.
Any other questions, Ms. Perkins, Mr. Honey? All right, if not, we're moving on. Thank you. Mr. Chairman, do you want to take another 5-minute break and let the room clear? All right, we're off the record.
Recording stopped.
I know.
Sure.
Sorry, yeah, take it. I see it.
Yeah. I know when you're ready to go, so I can let you play. I don't think heard Jim. Ready, Judge?
Recording in progress.
Hi, Commissioners, we are back on the record. Mr. Rankin has requested that his matter in docket number 095-2023-12 be moved up on the agenda because he has a witness that has something exigent in terms of leaving. So with the commission's indulgence, is it okay if we take up Mr. Rankin's matter before everybody else's? All right. So that matter is docket number 095-2023-12. Merit Energy Company is the applicant. The attorney, as I stated, is Mr. Rankin. Subject is extension of temporary abandonment status Location, section 34 Township 8 North, Range 13 West, Rockland County, B43 well spacing area. Mr. Rankin, you are recognized.
Thank you, Judge Molden. The list of pre-filed exhibits appear on page 2 of this application. They are Exhibit A, the list of parties receiving notice. Exhibit B is a fluid level test dated November 1st, 2023. Exhibit C is a proof of publication, and Exhibit D is the affidavit of notice to interested parties. Originals of C and D have been provided to counsel for the commission. We'd move for the introduction of the exhibits into the record.
Your motion is granted. Those exhibits are made part of the record. Commissioners, do you have, is there any recusals on this matter? I will note for the record there were none. Mr. Rankin?
Thank you, Judge. This is for the Stevenson 8-13 1-34H well. Originally granted administrative approval for TA status in 2017. Merit then moved in 2020 to extend it. And now we are here to ask for the second extension. With me at the table is Matt Collins from Merit. He is an engineer, but he's not here not today to offer an expert opinion. So we aren't having him recognized, but he is a party representative to explain the reason for the request. But before I get to ask Mr. Collins any questions, I do want to point out that there is a surface use agreement in place for this well site. Also, the Woolley 8-13 2-22H34 well also produces from the unit that the subject well is located, so it will continue to be held by production. But with that information, I would like to have Mr. Collins sworn and ask him a couple of questions.
Sir, would you be so kind as to raise your right hand? Do you swear or affirm the testimony you're about to give in this hearing is going to be the truth? Thank you, sir. Rankin, please proceed.
Please.
Yes, I'm Matt Collins.
How are you employed?
I'm an operations engineer with Merit Energy Company.
Okay, you heard me just explain to the commission about this being the third request. Could you explain to the commission what is necessary to bring this well back into operation?
Yeah, so this Stevenson 1 is a well that Merit has on its reactivation list. In order to reactivate this well, we would have to get slick line on location and swab down the existing fluid level. And then be able to kick the well off with gas lift after that to be able to produce it at an economic rate. With that factored in, and the high water production, factoring in the permanent compressor that we'd have to have on location, have high operating costs behind that. And with those costs, an overall gas price of $3.70 per MCF is required in order to call this project economically viable.
So the break-even price of gas to make this the workover economical was $3.70.
Yes, sir.
Okay. And just so the commission kind of has some degree of comfort that this isn't an application just to kick the can down the road, I'd like you to maybe tell them how many wells has Merit plugged so far this year in its plugging program?
In 2023, Merit has plugged 25 wells.
And looking for, you got any idea what's coming up?
And heading into 2024, we're going to be close to that number. That is what we're estimating to be 25.
So then this application certainly isn't in that category of kicking the can down the road on this one. Do you think there is some economic life left in this well?
Yes, that's correct.
In your opinion, any requirement by the commission to plug and abandon this well, could that lead to causing an economic waste for Merit and the correlative rights of those involved?
Yes, that's correct.
That's good.
Commissioners, any questions? Rankin?
No, brother.
All right, I'll call the evidentiary record to a close then. Any abstentions based on the evidence adduced? For the record that there are none. This matter is ready for adjudication. Is there a motion from the commission? Motion from the Chair Langley. Second from Commissioner Lawson. Any other further discussion? If not, show of hands. 8 votes, motion passes. Thank you, Mr. Rankin. Mr. Daly?
Mr. Perkins has graciously allowed me the opportunity to go before him so that we can drive to Northwest Arkansas.
Mr. Daly, are you here on, 92?
Yeah, I am, Mr. Rankin's other case.
Okay. Commissioners, is that okay with you? All right.
Yes, sir.
All right, next item on the agenda is docket 092-2023-12. Merit Energy LLC, Oxley Energy is the applicant. Mr. Daly is the attorney, subject to the transfer of well location, section 24, township 5 north, range 30 west. Scott County B44 well spacing area is the field. Mr. Daly, you are recognized.
Sir. Commission General Rule B4H4 specifies that a well making less than 25 MCF per day cannot be transferred without approval of the commission and a $35,000 bond being posted. There is such a well in section 24 Township 5 North, range 30 west in Scott County. It's called the Gray number 2 well. There were 2 working interest owners in the unit. There is now 1. Merit has sold all rights in the Gray unit to Oxley, and Oxley wishes to assume the operations of the Gray number 2 well, which at the moment at least makes less than 25 MCF a day. Mr. Mark Wilson and
Hold on, Mr. Daly. Let me ask 2 things. One is, Mr. Daly set the table any recusals from the commission based on what he has stated. I'll note for the record there were none. Mr. Daly, do you have any exhibits that you need to introduce?
yeah, I'm going to in just a second.
Okay.
We have 2 witnesses, Mark Wilson and Jeff Gibbs. Jeff is an expert in petroleum geology, having had his credentials first recognized in order reference number 65-2006-03. We have pre-filed exhibits, including Exhibit G, which I handed to each commissioner this morning, and Exhibit G and the court reporter, and Exhibit G itemizes the other exhibits. We move the admission of those exhibits into evidence, the incorporation by reference of Mr. Gibbs' credentials, and that requests that the witnesses be sworn.
Motion is granted. Your exhibits are made part of the record. Gentlemen, would you be so kind as to raise your right hands? Oh, you swear from the testimony about to give in this hearing is going to be the truth. Thank you both. Mr. Daly?
Grab that mic so that they can hear you. State your name and employment.
My name is Mark Wilson. I'm Arkansas Land Manager for Oxley Energy LLC.
Are you familiar with the transaction ongoing whereby Oxley is purchasing all of the interest of the other working interest owner, that being Merit, in the Gray unit?
Yes.
When the transaction is completed, is it true that Oxley will be the only working interest owner in the wells in the unit?
No, we'll be the only working interest owner in the Gray number 2 well.
Gray number 2 well. You have internal partners in some of the other ones.
No, we have 2 partners, Southern Resources out of Oklahoma City and Hanover Gas.
That's why we have a list of interested parties. What is the configuration of the physical configuration of the wells vis-a-vis the pipeline, the market, and the grid?
Well, there's a pipeline that goes north-south, energy transfer pipeline that goes north and south, and the Gray number 2 lies on that particular pipeline.
And so is it going to result in any significant additional expense for you to take over the Gray number 2?
No.
And the Gray number 2 well is capable of producing gas?
Yes.
All right. Any questions for Mr. Wilson?
Commissioners, any questions? Apparently not, Mr. Daly. Next witness.
Please state your name.
My name is Jeff Gist.
And are you employed as a geologist for Oxley?
Yes, I am.
What do you intend to do with the Gray number 2 well if the transfer of operations is approved?
We plan to, when we operate, study, and watch production rates. We operate 2 additional wells in the unit, the grade number 4 and the grade number 5D. And this will gain additional gas with little or no additional cost.
In other words, the grade number 2 well, while it is making less than 25 MCF a day, will cash flow.
Yes.
And therefore, is it your opinion that if it were required to be plugged at this time, natural resources would be wasted?
Yes.
And commissioners, you will notice Exhibit B is the $35,000 bond that has already been prepared by Oxley and approved by the surety. That concludes our presentation.
Commissioners, any questions? Anything further, Mr. Daly? If not, I'll call the evidentiary record to close. This matter is ready for adjudication. Any abstentions from the commission based on the evidence adduced? Motion made by Commissioner Weiser to approve. Is there a second? Second by Commissioner Phillips. Show of hands. 8 votes yes, motion passes. Thank you, Mr. Daly. Oh, thank you.
See.
All right, next item on the regular docket, docket number 079-2023-10. Applicant is Flywell Energy Production LLC. Attorney is Mr. Perkins. Subject is an authority to commingle production, approval of production allocation methodology. Location section 31, Township 8 North, Range 11 West, Cleveland County, B43 well spacing area. Commissioners, any recusals on this matter? 2. I have Commissioner Weiser and Commissioner Wolford who are recusing. Mr. Perkins, you are recognized.
Thank you, Judge. The pre-filed exhibits are listed on page 2 of the application. Those include Exhibit A, a list of parties receiving notice. B is the Packer removal allocation proposal for the SNEED 911-9-31H19. C is a spreadsheet listing the working interest owner responses to the proposal. D is a proof of publication. E is an affidavit of notice. The originals of D and E have been provided to Mr. Pilkington already. In addition, I've just handed out to each of you a supplemental Exhibit F, which is just a well layout map that Southwestern Energy did when they drilled the well. I think it'll be useful in explaining the situation here. I would ask that all of those exhibits be admitted to the record.
Your motion is granted. Exhibits are admitted into the record.
I have 2 witnesses with me today, Chris Lancaster with Land and Colin Fike, who's an expert in petroleum engineering. Mr. Fike's qualifications were first recognized by this commission in docket number 107-2022-12. Would ask that Mr. Fike's qualifications be admitted and incorporated and that the witnesses would be sworn.
Motion granted in terms of incorporating their credentials into the record. Gentlemen, would you be so kind as to raise your right hand? You swear from the testimony you're about to give in this hearing is going to be the truth. Thank you both.
All right, just as a reminder, this docket was called in October. We didn't have enough commissioners for a quorum, but I was allowed to make a correction because the face of the application had the wrong township range and section listed. That was corrected. We've also then re-noticed everyone, and the originals of those notices have been provided to Mr. Pilkington. The correct township range and section is section 31, township 9 north, range 11 west. So I just wanted to remind the commission of that correction that was made last time. Let me give you, if I may, just a little bit of background because I think it'll shorten things. So this is a commingling application where Flywheel is requesting to commingle production from the Hale Formation with production from the Fayetteville Shale Formation. Previously and in the past, those were produced separately, one up the tubing, one up the casing. They were separately metered. And Mr. Fike can explain to you the problems that have been encountered that are leading to this application. But I wanted to give you this background. So originally, there were 4 horizontal wells drilled off this same pad. And so if you would refer to the supplemental exhibit F that I passed out to you, this was Southwestern Energy's exhibit back at the time of this original application. And you'll see the yellow highlighting around the well pad. There were 4 wells that all extended northward from the pad. The pad is located in section 31, goes through the entirety of section 30 and ends at approximately the section boundary between 30 and 19 to the north. When they drilled the wells, there was pressure on the surface casing in all 4 wells. And there was an emergency order to flare that gas pending an full application before the commission back at that time. SECO believed that the Hale Formation was the source, and so what they proposed to do was to complete the Hale Formation in one of the 4 wells. It's the well that's on this application, the number 9 well, in order to relieve the pressure in all of the wells. That was successful. And at the time then, the Fayetteville production was allocated to all 3 sections pursuant to the normal formula, 30, 31, and 19, because it's too close to the section line to meet the setback requirements. But the commission then heard the information about the Hale production and determined on an application of SECO in the alternative, either for an exceptional location or to allocate the production between sections 30 and 31 for the Hale, since it's a conventional formation, not Fayetteville Shale Formation. That was granted, and the commission determined that the production would be allocated only between sections 30 and 31 on a 60% to section 31 and 40% to section 30. And that's Commission Order number 101-3-2012-05. And we would ask that be included in this record as well. So that's where we are today. We're asking for, we're going to continue, the point is to continue the same allocation, but now we're going to commingle, and Mr. Fike can explain how we're going to, how they intend to allocate that production between Hale production and Fayetteville Shale production. But I felt it was useful to kind of understand the history of how we got here today. So I'll begin with Mr. Fike. Attached to the application was really a report, I'll call it, or a memo prepared by Mr. Fike that explains the situation. And I'm going to ask him if he can just to summarize it or walk you through that with reference to the various graphs and the calculations to explain what it is that Flywheel is proposing. First, let's start out with what's the problem? Why are we having to do this today, Mr. Fike?
Yes, we've been having problems with the Hale production of the casings for large flow area flow up. Can't really liquefy that formation very well, so it loads up. There's very little we can do. We've attempted to pump foam slurries, and shut in extended pressure buildups and flow of hail production, without very much success. So that hail production has fallen off. We're not producing what it is capable of producing. On the other side, the Fayetteville producing up the tubing, we've installed a plunger lift system. It's doing a great job liquefying that zone. So what we're proposing is to remove the packer, essentially flow the hail production down the casing annulus of the tubing, commingled downhole with the Fayetteville coming up the tubing, so we can use the plunger lift system right there to help liquefy that zone and get most of the gas production back from that zone.
Okay, so since under this proposal, then the Hale and the Fayetteville would no longer be separately metered, how would Flywheel determine how to allocate the gas being produced as identifying it as either Fayetteville gas or Hale gas, so that the allocation of royalties is proper?
Yes, so we do regular gas analyses, and there's quite a bit of data provided in the report showing the historical trend of BTU content of the gas. The Hale formation has been very stable, very consistent. BTU content averaging 1,012 BTUs per foot cube, whereas the Fayetteville is declining over time as the CO2 emissions increase. So what we're proposing is by just after we commingle the two wells, we'll have regularly scheduled gas analyses. We will measure the current BTU content of the gas, and then we can take baseline ratios and determine how much gas is coming from each zone. Because the BTU content of the Fayetteville has been declining, I looked at the offset wells on either side, and they show the exact same decline in BTU content. So we can use them as an analog of what the BTU content of the Fayetteville formation will continue to do over time. And we are assuming from historical trend that the Hale will continue to be flat. So in this way, we can proportionally distribute the BTUs, the BTU content, the volume of sales to each zone, and then the normal allocations between sections and royalty owners for futures partners will be unchanged.
So you would do monthly gas analyses both in this well to determine the mixed BTU, and then you would also do a monthly analysis in one or both of the adjacent Fayetteville wells to determine the current content, BTU content of the Fayetteville gas. Is that right?
Yes.
And once you have those two numbers, it's just a math problem to determine the percentage of gas being contributed by the Hale formation versus the Fayetteville Shale formation. Is that right?
Yes. Example of a math problem with theoretical, what numbers that could be realistic in the future. Follow through all of the energy content balances out. So the mixed stream, the total BTUs that are produced up the wellbore will be allocated to the zones.
Any questions for Mr. Feig from the commission?
Commissioners, any questions? Oh, sir.
All right.
Next witness.
Mr. Lancaster, what is your position with Flywheel?
I'm a land associate.
All right, and have you been responsible with regard to this application for the correspondence with the working interest owners in these units about this application?
Yes.
And what type of, summarize for the commission, if you would, the responses that you received from the working interest owners?
Yes, so we received consent from 99.84% of the working interest partners and no response from 0.16%, which makes up just 3 partners.
And
oh, yeah.
With regard to those, so that those other, it's quite common, is it not, that some of these really minor participants just don't respond to these types of requests for consent from Flywheel?
Correct.
And so what you're asking the commission to then approve this without regard to those that just chose not to respond?
Yes,
Did you make multiple efforts to try to contact them?
we have.
But with regard to all of the others who did respond, those were all in favor, those were consent responses, correct?
That's correct.
That's all I have.
Commissioners, any questions? Anything else you need to add, Mr. Perkins?
No, I just wanted to point out that we're not proposing to change anything about the allocation of proceeds from either formation. We're going to follow Flywheel is going to continue to follow the orders that are already in place. It's merely a difference in the mechanism for determining how much gas came from each source.
With that, I'll call the evidentiary part of the record to a close based on the evidence elicited. Any abstentions? This matter is ready for adjudication. Is there a motion from the commission? Motion by Commissioner Lawson, second by Commissioner Thomas. Any further discussion? Seeing none, all in favor, signify by raising your hands. I have 6 yes votes. Motion passes.
Thank you.
Next item on the agenda is docket 085-2023-12. Applicant is Flywheel Energy Production LLC. Attorney is Mr. Perkins. Subject is extension of temporary abandonment status. Location is section 12, township 8 north, range 15 west. Conway County, B43 well spacing area is the field. Mr. Perkins, you are recognized.
Thank you, Judge Moulton. The pre-filed exhibits are listed on page 2 of the application. Exhibit A lists the parties receiving notice. B is a fluid level test, November 23rd, 2022. C is a proof of publication. D is an affidavit of notice. The originals of C and D have been provided today to Mr. Pilkington. I would ask that those exhibits be admitted.
All right, before we get into that, any recusals from the commission? So for the record, there were none. Your motion is granted. Those exhibits are made part of the record.
All right, we'll try to click through these as quick as we can. All of these, my remaining applications are temporary abandonment extensions. This one is no different. The Anthony DeSalvo Trust 815-2-12H well is the one that's the subject of this application. The applicant needs to install a plunger and possibly perform a lateral acid treatment. The applicant wants to retain this well for economical return to production. There is a surface use agreement on the well site. And of course, the applicant agrees to all the commission imposed requirements, including the continuing the bond that's already in place and the imposed restriction on prohibiting the transfer.
Any abstentions, commissioners? Anything else you need to add, Mr. Perkins?
So, oh, I'm sorry. Yes, $4.32 is the estimated break-even price.
Any other questions for the commission? If not, I'll call this matter, the evidentiary part of the record, to a close. This matter is ready for adjudication. Is there a motion from the commission? Next item is docket number 08. Applicant is Flywheel Energy Production. Attorney is Mr. Perkins. Subject to extension of temporary abandonment status. Location section 15, township 10 north, range 16 west. Counties Van Buren. Field is B43 well spacing area. Any recusals on this application? No, for the record, there were none. Mr. Perkins, you were recognized.
Thank you, Judge Moulton. Before I get into that application, I just wanted to also give you an update as I do from time to time. This time I compiled the data from 2020 through 2023, just so that you know these are not all being done so that they don't have to do anything. During that 4-year period, Flywheel has returned 114 wells to sales from temporary abandonment status and has plugged and abandoned 107. So I just wanted to give you that information. because it's good to know that they're active on both fronts. And I assume there is a schedule of wells that are to be P&A'd, that Director Bingle would know. I don't have those numbers in front of me. But they continue to do work on both fronts to manage their wells properly. The originals, or I'm sorry, the exhibits that were attached to the application are listed on page 2. Those include Exhibit A, a list of parties receiving notice. B is a fluid level test of November 23rd, 2022. C is a proof of publication. D is an affidavit of notice to interested parties. The originals of C and D have been provided today to Mr. Pilkington. I would ask that those exhibits be admitted.
Motion is granted. Those exhibits are made part of the record.
This is another temporary abandonment extension application for the Green Bay Package 10-16 2-15H well. The applicant needs to replace tubing and install a plunger. The applicant wants to retain this well for economical return to production. The estimated break-even price is $4.86 an MCF. There is a surface use agreement on the well site, and Flywheel would, of course, agree to the commission imposed restrictions and continuing the individual well bond.
Any questions from the commission? Anything?
What's the cause? And you may know, what's the cause of the place?
Well, I don't know. Our engineer might be able to answer that question, but I assume it would vary from well to well.
I don't want to slow it down.
Or perhaps Commissioner Walford would.
Anything else from the commission? Anything else from you, Mr. Parkins?
Nothing further.
All right. With that, I'll call the evidentiary part of the record to a close. This matter is ready for adjudication. Is there a motion from the commission? Motion made to approve by Commissioner Phillips. Is there a second? Second by Commissioner Lawson. Any further discussion? All in favor? Motion passes, 8 votes. Next item is docket number 087-2023-12. Flywheel Energy Production as the applicant. Attorney is Mr. Parkins. Subject is extension of temporary abandonment status, location section 34, Township 10 North, Range 16 West, Van Buren County, B43 well spacing area. Any recusals from the commission on this application? Now, for the record, there are none. Perkins, you are recognized.
Thank you, Judge Moulton. The pre-filed exhibits are listed on page 2 of the application. Those include Exhibit A, a list of parties receiving notice. B is the fluid level test of November 23rd, 2022. C is the proof of publication. D is an affidavit of notice. The originals of C and D have been provided to Mr. Pilkington. I would ask that those exhibits be admitted.
Motion is granted. Those exhibits are part of the record.
For this particular well, the Coon 1016 2-34H well, the applicant needs to reinstall a plunger equipment and possibly perform a pump tubing acid job. The applicant wants to retain this well for economical return to production. The estimated break-even price for those operations is $2.37. There is a surface use agreement in place, an individual well bond, which will be continued, and the applicant agrees to the other commission imposed restrictions.
Any questions from the commission?
Yes, sir. I do not know.
Okay.
Sometimes, you know, the order in which they are taken is a logistical question. So they may be, they may plan to do 2 or 3 wells in a particular area at the same time, or for other logistical reasons. It's not just all in order based on break-even price. I appreciate that, Commissioner Phillips.
Any other questions from the commission? Anything else you need to add, Mr. Perkins?
Nothing further.
Thank you, sir. I'll call the evidentiary record to a close. Matter ready for adjudication. Is there a motion from the commission? Chair Langley has made a motion to approve the application. Is there a second? Commissioner Liner has seconded. Any other discussion? If not, show of hands. 8 yes votes, motion passes. Next item is docket number 088-2023-12. Applicant is Flywheel Energy Production LLC. Says here the attorney is Forrest Stovall, but I don't think you look
No,
like
that
him,
was,
Mr. Perkins.
that was a mistake.
Yeah. Subject is extension of temporary abandonment status. Location is section 3, Township 9 North, Range 14 West, Counties Van Buren. Look, field is B43 well spacing area. Any recusals from the commission on this matter? So for the record, there were none. Mr. Perkins, you are recognized.
Thank you, Judge. The pre-filed exhibits are listed on page 2 of the application. Those include Exhibit A, a list of parties; B is a fluid level test of December 22nd, 2022; C is a proof of publication; D is an affidavit of notice. The originals of C and D have been provided to Mr. Pilkington. I would ask that those exhibits be admitted.
Motion is granted. Forgot to ask for recusals as I rapidly go through this. No, for the record, there are none. Please proceed, Mr. Perkins.
Thank you. So the Mills 914 2-3H well needs a plunger installation and an acid treatment. The applicant wants to retain this well for economical return to production. The estimated break-even price for this well is $3.45. There is a surface use agreement in place, an individual well bond that will continue, and the applicant would agree to the other commission-imposed restrictions.
Commissioners, any questions? Anything else you'd like to add, Mr. Perkins?
Nothing further.
All right. The evidentiary record to a close. I know there are probably no abstentions as well. Matter is ready for adjudication. Is there a motion from the commission? Commissioner Weiser has moved to approve. Is there a second? Commissioner Phillips has seconded. Further discussion? Not show of hands. 8 yes votes, motion passes. Next item is docket number 089-2023-12. Applicant is Flywheel Energy Production. 20 is Mr. Perkins. Subject is extension of temporary abandonment status. Location is section 15, Township 8 North, Range 13 West. Rockland County is the county. Field is B43 well spacing area. Any recusals? No, for the record, there are none. Mr. Perkins, you are recognized.
Thank you, Judge. The pre-filed exhibits are listed on page 2 of the application. Those include Exhibit A, list of parties; B is a fluid level test of December 22nd, 2022; C is a proof of publication; D is the affidavit of notice to interested parties. The originals of C and D have been provided to Mr. Pilkington. I would ask that those exhibits be admitted.
Motion is granted. Those exhibits are part of the record.
This particular well, the Stevens John 813 1-15H well, needs reinstallation of a permanent gas lift compressor and likely will need H2S separation equipment. The estimated break-even price of those operations is $3.82. There is a surface use agreement in place on this well site. The individual well bond in place will be continued, and the applicant would of course agree to the other commission imposed restrictions.
Thank you. Any questions from the commission?
No,
Just a second, I'll tell you.
It's not, yeah.
I'll let you know. I just don't know the answer to that. I didn't think it was a Moorfield well.
Any other questions from the commission? Anything further from you, Mr. Perkins, on this?
Further.
All right, if that's the case, any abstentions based on the record? No, for the record, there are none. This matter is ready for adjudication. For motion from the commission. Motion from Commissioner Phillips to approve, second. Second by Commissioner Weiser. Further discussion? If not, show of hands. Motion passes 8 votes. Next item is docket number 090, 2023-12. Applicant is Flywell Energy Production. Attorney is Mr. Perkins. Subject is extension of temporary abandonment status. Location is Section 1, Township 9 North, Range 14 West, Van Buren County, B43 well spacing area. Any recusals on this matter? No, for the record, there are none. Mr. Perkins, you are recognized.
Thank you, Judge. The list of pre-filed exhibits is shown on page 2. Those include Exhibit A, a list of parties receiving notice. B is the fluid level test of January 27th, 2022. C is the proof of publication. D is an affidavit of notice to interested parties. The originals of C and D have been provided to Mr. Pilkington today. Would ask that those exhibits be admitted.
Motion is granted. Those exhibits are made a part of the record.
This particular well, the Whisenhunt 914-2-1H well, the applicant has indicated that this well needs to perform a wireline pump down, run a hole finder, and possibly a plunger installation and permanent compression. The applicant wants to retain this well for economical return to production. The cost of those operations indicate an estimated break-even price of $3.08. There is a surface use agreement in place. There is an individual well bond in place that will continue, and the applicant agrees to the other commission-imposed restrictions.
Ms. Perkins, any questions from the commission? Anything further that you need to add?
Nothing further.
Call the evidentiary record to a close. The matter is ready for adjudication. Is there a motion from the commission? Chair Rangley has made a motion to approve. Is there a second? Commissioner Lawson has seconded. Any other discussion? If not, show of hands. 8 votes yes, motion passes. Mr. Perkins, winding it up here. Next item is docket number 091, 2023-12. Applicant is Flywell Energy Production, LLC. Attorney is Mr. Alan Perkins. Subject extension of temporary abandonment status. Location Section 22, Township 8 North, Range 13 West, Whatcom County, B43 well spacing area. Any recusals from the commission? No, for the record, there are none. Mr. Perkins, you are recognized.
Thank you, Judge Moulton. The pre-filed exhibits are listed on page 2. Those include Exhibit A, a list of parties receiving notice. B is a fluid level test of December 22nd, 2022. C is a proof of publication. D is the affidavit of notice to interested parties. The originals of C and D have been provided this morning to Mr. Pilkington. I would ask that the exhibits be admitted.
Motion is granted. Exhibits are part of the record.
The Woolley 813-1-22H well requires installation of a plunger system, the reinstallation of permanent gas lift compression, and likely will need H2S separation equipment. The applicant wants to retain this well for economical return to production. The estimated break-even price is $4.70. There is a surface use agreement in place on the well site, an individual well bond in place that will continue, and the applicant would agree to the other commission-imposed restrictions.
Thank you, Mr. Perkins. Any questions from the commission? Anything else you'd like to add, Mr. Perkins?
Nothing further.
All right, thank you, sir. Call the evidentiary record to a close. Matters ready for adjudication. Is there a motion from the commission on this application? Mr. Weiser made a motion to approve. I'm going to say that.
No, that was new Commissioner
Westphal.
We don't want to get that one wrong.
I'm gonna call his a second.
Oh, okay.
That's judicial prerogative right there. Motion made, seconded. Any other discussion? If not, show of hands. 8 votes, motion passes. Thank you very much, Mr. Perkins.
You're up next for I'm gonna look at these for the next one here. Next item on, the executive staff. Document 093-8-2023-12. Operator is Viva SWD LLC. Subject to development management. Location is section 20 conservation or regulations, but having posted the field this morning. Any refusals on this matter? So for the record, there were none. People, you are recognized.
Thank you. I have several pre-filed exhibits I would make for admission of. They include Exhibit A, which is the Form 1 organization report. Exhibit B is the affidavit of notice. Exhibit C is the copy of notice of hearing. Exhibit D is a previous commission order issued this year, order number 009A-2023-1. Exhibit E is the proof of public notice from the Arkansas Democrat Gazette. I would move for admission of each of these exhibits into the record.
Motion is granted. The exhibits are part of the record.
Okay, at this time, I would like to call testimony from Mr. Hanson.
Would you be so kind as to raise your right hand? Do you swear or affirm the testimony about to give in this hearing is going to be the truth?
I do.
Thank you, sir. Please proceed, Mr. Pinkleton.
Thank you. Mr. Hanson, you work at the commission, correct?
Correct.
And you have knowledge of the operations of the Reba 220 well, is that correct?
Lack of operation, yes.
Lack of operations. Let's go into that in a little bit more detail. Earlier this year, there was an application filed by commission staff to compel this operator to the well, is that correct?
Yes.
And previously, how did the commission rule on that application?
They gave the operator 60 days to plug the wells. 60 days being the date of the injury.
So 60 days from the date that was provided in the order, they were supposed to plug the well. Did the operator plug the well within that time frame?
No, they did not plug the well, nor did they make any contact with staff.
And is it your understanding that this well should be declared abandoned because the commission ordered the permit holder to plug the well and they did not comply with that order?
Yes.
Okay. I have no further questions from this witness.
Commissioners, any questions?
I believe the bond has been called.
Currently, I can answer that. I'm sorry. We filed a bond forfeiture. The time period for the operator to contest that bond forfeiture ended, I believe, last week. We are currently in the process of doing a site draft to recover that bond. The concern here is that even if we do have the bond, we may not have sufficient funds to plug it with just that funding. So we're requesting that this well be put into the AOW program in case there's any overage.
$50,000 commercial well.
Yes.
Any other questions from the commission? Seeing none, Mr. Pinkleton, anything else you'd like to add?
Nothing further.
If not, I'll call the evidentiary record to a close. The matter is ready for adjudication. Is there a motion from the commission? No, I'm going to skip over you this time, Commissioner Weiser. Yep. Commissioner Westfeld made a motion to approve, second by Commissioner Weiser. Any other discussion? All in favor, show of hands. 8 votes yes, motion passes. Next item has been continued, docket number 094A at the request of staff. So we are jumping to docket number 096A-2023-12. There is no operator on this one. We just have an attorney, Mr. Pinkleton. The subject is the request for director's authority during lithium exploratory operations. Locations are multiple, county and field are multiple. Mr. Pinkleton, you are recognized.
Yes, I believe commission staff has some explaining to do here, and we plan on doing that. First, there are 2 pre-filed exhibits I would move for admission of. That includes Exhibit A, the notice of hearing, And Exhibit B is the proof of publication of notice of hearing. I would move for admission of each of those exhibits into the record.
Motion is granted. Exhibits are part of the record. I did gloss over recusals because I don't know what they're even recusing on, and neither do they probably. So go ahead.
Fair enough. And through previous discussions with Director Bingle, I believe that there were certain activities going on during lithium exploratory operations that the director wanted to clarify and make sure that he could get authorization to grant administratively. At this time, I'm going to defer to Director Bingle to explain what those activities are.
Please proceed.
As the commission is aware, we do not have a complete set of rules dealing with brine production. We have a brine statute. We have some orders dealing with the class 5 wells. And we have incorporated brine production wells, injection wells in some of our other general oil and gas rules. All these were adopted when brine production was already established and existing prior to the statute being adopted and prior to our rules. None of those rules really cover what's going on with the lithium exploration. We permit a well, but prior to commercial production, until we approve that, there needs to be provisions in the drilling permits that we want to put as drilling permit conditions to do step rate test, injection test, production test, sampling, all sorts of protocols during the exploratory phase of the lithium projects prior to us determining the royalty payment, which then after which, commercial production could begin. Rather than doing that hearing by hearing, and for you to do that on each individual well, what I'm proposing in the letter before you is a list of items that I would approve administratively as permit conditions to the permits issued in the brine or in the lithium exploratory areas, primarily with saltworks, etc., and standard lithium in their west unit, not in the south unit that they're dealing with lengths of salt. Now, answer any questions you have on what I listened to.
Any questions from the commission?
I think there's some discussion as to and adding to your letter, giving you the authority to request all people seeking a permit for lithium test well, extraction well, or injection well be required to file an electric log from the base of the well to the base of the surface case.
Okay.
It can be added in there. That includes a D in whatever language you choose, whichever type of log at the director's discretion.
Okay.
If there's an intermediate strike, it needs to be before they set that, so they can grab the base of the surface.
Okay.
Any other questions from the commission?
Do we want to say it's set a minimum set of laws, like combo?
Platform, something like that. Do you want a density and a conduction? Yeah. Okay.
Did you receive any comments on the notice?
We did not.
This will just streamline the whole process. We've been just authorizing things in the interim, but this is going to require a lot more over the next year and a half prior to commercial production beginning in a couple of years from now. Anything in this about core analysis? They're recording and getting their information. They report that on a Form 3 completion report. The analysis is their information. It's not required to report other than a core was taken. I've asked them to, when they do core, when they're done with the analyses, if they want to voluntarily contribute that to the geological survey, they can then stay on file.
Any other questions? Pinkelton, anything else you need to add?
Nothing further.
With that, I'll call the evidentiary record to a close, commissioners. Matters ready for adjudication. If you want to make a motion to approve staff's request with the caveats that Commissioner Thomas added to staff's request. All right. Commissioner Lawson has moved to approve as amended, second by Commissioner Liner. Any further questions or comments? If not, show of hands. Motion passes 8 votes. Thank you, Mr. Pinkerton. For our open docket, Commission will now hear public comments concerning the following areas of commission jurisdiction: whether or not waste of oil and/or gas is taking place or is reasonably imminent, the optimum equitable rate of production for each controlled source of supply, whether or not any rules and regulations currently in effect should be considered for revision, or if additional rules should be considered, other matters brought before the commission over which it has jurisdiction. I will note for the record, there was no response from those present. Director Bengal.
Okay, couple things we have to go through real quickly. on it's late in the day. Minutes from last meeting will be posted on the webpage as approved. You have 2 letters from you in front of you from DOT PHMSA. They were addressed to Chairman Langley, but these are 2 letters that were sent reviewing our underground storage program and our natural gas pipeline safety program. That we received 100% on both of those reports. As we have a good program. I thank Gary Looney and Brian Brown and Ryan in Ellenberger and Fort Smith for assisting Gary and having a good program for that. We look forward to potentially, if we need to change our statute to include liquid pipelines also in our program, which will allow us then to regulate CO2 pipelines, should the CO2 industry commence here in Arkansas. The last thing that's approved is our minutes for our meeting agenda for next year, 2024. You have that for you. We're proposing, given the actions today concerning the lithium royalty hearing, the January 23rd meeting would be here in Little Rock in person. That would be the only change to the list you have before you, and proposing that all the meetings begin at 9 a.m. In that basis. That would be one less meeting at Fort Smith, but given the circumstances, it's the easiest change to make. So we have your approval for this hearing schedule as proposed with that one change. New motion. All hearings will start at 9 since so you can come down the night before and stay. There's no problem with doing that. Hot Springs one is 1 p.m. But you can stay the night after.
So if we still gonna have one in Little Rock on the 25th.
Of June? Yes.
All the change is.
The first January 23rd one.
And is it 10 o'clock or
9 o'clock. All of them will be 9 o'clock.
Okay. It's going to be where now?
Here. And that's the purpose of that change. At 1. The one in Hot Springs is the racetrack convention center will be at 1 p.m. All the hearings, North Little Rock, Hot Springs, or North Little Rock, El Dorado, and Fort Smith will all be at 9 a.m. We'll strike that 10 a.m. start time red in the agenda, redo the agenda. So we have a motion to approve that with those changes? Little Rock in January in person.
Go ahead.
In person, in person. That's all that I have.
Recording stopped.
Yeah.